All right, I think we are ready whenever you are.
All right. I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Wednesday, January 28th, meeting of the municipal land use board of Riverbridge. This meeting of the municipal land use board of the Riverbridge is being held both in person and remotely through Zoom in compliance with provisions of the Open Public Meetings Act and associated regulations. Notice of this hybrid meeting was published in the Borough Record, posted at Borough Hall, and posted on the borough's website. The notice includes the dial-in login information necessary for public participation and access to this meeting. A copy of the agenda for this meeting is made available on the borough's website near the posting of the meeting notice and included the dial-in login information. Please silence all cell phones. During the public comment period of this meeting, if you would like to make a public comment, you may step up to the microphone and wait to be recognized by the chairperson. Press the raise hand button on Zoom or dial *9 on the telephone keypad to raise your hand. You may mute and unmute yourself by pressing the microphone icon on Zoom or dialing *6 on your telephone keypad. You must state your name and address prior to making the public comment. Two items on the agenda.
I'll take the roll call.
sorry.
I'm sorry. The mayor is excused. Mr. Caslin, the chairman, is excused. Mr. Cray?
Here.
Ms. Boland is absent at the moment. Mr. Gibbons?
Here.
Mr. Canigo?
Here.
Mr. Salva?
Here.
Mr. Gautier?
Here.
Okay. Councilman Glass is excused. And Ms. Levine?
Here.
All right, also present are special counsel, Mr. Liebman, our zoning officer is appearing via Zoom, Mr. Depkin, our board planner, Mr. Behrens, and our board engineer, Mr. Costa. Starting with the approval of minutes, the 114 meeting has been distributed to all professionals. Are there any edits, comments, changes, concerns? There being none, it's a motion to put the minutes as All right, and this can be a voice vote, so all in favor?
Aye. Opposed, abstained? Yeah.
All right.
I think the next item, we will have to switch to the swearing in of new appointments, council member David Glass, who move on to the memorialization of our board professionals. Start with the appointment of our board engineer, 2026, Alpha. To accept the
Mr. The motion was, who was the motion? Okay. And these can just be voice votes. Yep.
Favor? Same.
Chairman, thank you. Members of the board, thank you very much.
Board planner, Mr. Barron. There you go, second. Okay, all in favor?
Aye.
Opposed? Abstained? Passes. Welcome again.
Thank you for the consideration. Glad to be back.
In front of the board attorney, did I use some signing the desk?
Brown is the official name now, yes.
Brown, it's very, that's one.
So moved. Second.
Favor?
Aye.
Opposed and abstained?
Thank you very much. Looking forward to another year. And just a reminder to speak into the microphone and have your microphones turned on green. We're having difficulty hearing the recording. Okay, you just press the little button at the bottom.
Of course not.
Approval for subject billboard sign. I believe that we have already heard testimony. Question. Today here, from the town engineer. That Mr. John testified. Do you expect to have any other testimony absent from the others?
Well, all right, but yeah, we'll kick that with. Thank you. We'll call Mr. McDonough. As a reminder, I'm Robert Falkins from the Law Students Nisi, appearing on behalf of the applicant IL Services. As the chairman described on December 10th, we finished the testimony of the three witnesses. Because of the time restraint, Mr. McDonough will give the information. At the last meeting.
I didn't get not one motion.
Did you do this one or?
He
No.
does not. That's okay.
That's the.
Yeah, make,
We can start the cross-examination at the time, unless you want to have questions to the board or the board's questions or everything. We may want to hold that until after the objectors. Yeah. Not right now. Okay.
This time.
Anything else?
I have several, but we're going to pull out, but we're going to leave that rough presentation.
Thank
Not at this time.
Mr. Barry.
We do have some questions, so just a question of order of operations, if you prefer for me to ask my questions when I was adjusted, I could certainly cover.
My suggestion would be, let objectors counsel go first. The question may raise them, if you want to answer this.
Yes, that's right.
and you have to come up to the microphone. Is this just a statement,
Yeah.
like a public comment, or is this questions of the witness?
This is just gonna be a statement we have, the objectors. Mr. Kinsel's been here for several meetings. He's been trying to make a statement. We'll take this a little bit out of order, but let's give him an opportunity to do it, put his public comment on the record. And then he doesn't.
Let's do it wrong. I appreciate that. Thank you, counsel.
And if you just check that that microphone is on or use the other one. You have to speak pretty close to the microphone, sorry.
I'm very strong. You're just speaking loud.
So, my name is Christopher Kinzel. I'm a partner at the law firm Carr and Abramson. We are counsel for Grand Fork Associates. I'm going to be reading a statement on behalf of my partner, Bob Carr, who is a member of the Grand Fork Associates LLC. and I'll be reading it in his voice. I am Robert Picard. I am a partner in Grand Fork Associates LLC, the owner of 70 Grand Avenue. I am also the co-founder of Picard Abramson PC, which is occupied the 35,000 square foot second floor of 70 Grand Avenue since the building was opened more than 40 years ago. Over all that time, we have been a responsible member of the River Edge community. We have paid our taxes and care about our neighbors. In that regard, I wish to confirm that we support the position in opposition expressed by the adjacent landowner, Dark Star Development. I address you this evening in opposition to the application of the landowner at 41 Grand Avenue, variances to permit the construction of a highway billboard on its property. Our building is directly across from the location of the proposed billboard and will be significantly impacted by it. First, I wish to observe that although I live in another town in Bergen County, I have spent most of my working hours at 70 Grand Avenue, and therefore appreciate the beautiful town that River Edge is. There is a quiet residential tone to River Edge that is perceptible even in the commercial areas. A 60-foot high, two-sided, 14-foot by 48-foot billboard is not at all consistent with the tone of River Edge. If you look at the placement of similarly sized billboards along Route 4 to the east and the west, you will note that they are either in a strictly commercial space or in an open space. None of them are stuck into an office building park such as the area between Route 4, Grand Avenue, Main Street, and Kimmick Road. Simply, this billboard does not belong where it is proposed to be erected. In its application, the applicant indicates the billboard will, quote, benefit the public, close quote, by serving as a, quote, message board, close quote, to communicate news about events and news of River Edge, public service announcements. This is not correct. The applicant has assured the town that this billboard will be static, as contrasted with electronic billboards where the message can easily be changed by the minute. The message on this billboard will be a commercial message on behalf of a product or service provider and likely not change that frequently. Furthermore, even if this billboard had the ability to show community messages, the only way a River Edge resident would see the message is if they were driving on Route 4. With the overwhelming majority of River Edge residents living north of Route 4, the suggestion that this billboard as serving a community interest is silly. My principal concern about this billboard is the adverse economic impact it will have on our building, 70 Grand Avenue. Carl Abramson does occupy the top floor, but the 35,000 square foot first floor is occupied by other unrelated tenants. I don't know if you realize the challenges of being a landlord of an office building in Bergen County these days. Over the 40 years of owning, maintaining and investing millions in improvements to our building, rents have remained virtually static. The rents we can charge today are only 20% higher than the rents we could charge 40 years ago. Way behind inflation and certainly behind the increases we must pay for virtually everything we need to purchase to keep this building running as a Class A office building. With the shift of many businesses to remote working and other workplace changes, the rental market is extremely competitive as demand is low. Just look at the vacancy signs outside the commercial office buildings in town. Anything that reduces interest to rent in our space is detrimental. The western facing wing of our building on both floors will be facing this proposed billboard. Please refer to the photos in the Costa Engineering Report, page 27. Our rental agent has been clear that we will find it more difficult to rent those spaces facing the billboard as many tenants will be, quote, turned off by the view. By contrast, tenants of 41 Grand will not have to deal with the views of the billboard because it's on top of them, not facing their windows. I respectfully ask you to please consider the inequity of that situation I also respectfully point your attention to the size of the proposed installation. Each of the two billboards is 14 by 48 feet, which is 672 square feet. Two billboards are hinged at the end and spread open at the other end to facilitate appropriate angle of viewing from either direction on Route 4. At the end where they are spread open, the distance between the two billboard elements is stated on the application to be 20 feet, plus the dimension of the steel walkway. The square footage of that triangle is 480 square feet, and the volume is 6,220 cubic feet. Of course, this sign will be lit for viewing, which during the winter months means this billboard will be lit in the late afternoon when tenants are in the offices facing this billboard. The billboard will be a significant structure set at a height that is higher than adding another floor to the building at 41 Grand Avenue. Finally, I asked the board to please consider what it would do if presented with an identical application for an identical billboard, 14 by 48 and 60 feet high, adjacent to the hypothetical office building across from the Borough Municipal Building. Even without the economic issues I've raised, I doubt you would approve it. I ask you to do the same in this case. Thank you for the opportunity to present to you today.
I think that one does work, just needs to be turned. You could fit or whatever you like. Or you could pull up a chair.
Good evening, Chairman, members of the board, Councilor, Madam Secretary, Charles Sorlow on behalf of Darkstar Development LLC, which is the property owner of Block 1405, Lot 3, as well as Let It Grow, who is the primary proposed tenant for that particular building. Common address is 335 Johnson Avenue. Good evening, Mr. McDonough.
Good evening.
Good to see you.
Michael.
Okay. So you concluded your direct examination in this case, which is the subject matter, the billboard, is that correct?
Correct.
Okay. And during your testimony, which I have an unofficial transcript of your testimony with me, since it was a few months ago. But during your testimony, you testified that you reviewed the town's zoning ordinance and the master plan.
I did, yes.
As well as you reviewed the application itself and the plans. that were
Yes.
submitted. I think your testimony was that based on the review of the zoning plan, the master plan, the application, and the plans, that there were two use variances that were required. One use variance being that no billboards were permitted in any district, and the second use variance because there are two principal uses on the same site. Is that correct?
Yes.
Okay. So I think if we need to refer to it, I have a printout of the section of the zoning variance. So section 416-45 of the.
Is that microphone still on?
Yeah, fine.
It's on now, okay. Just repeat your questions, yeah.
So just to repeat, to make sure it's on the record. You concluded, based on your review of the matter of zoning plan and master plan, that there were two use variances. One, the billboards not being permitted in any district in town, and the second use variance being for two principal uses on the same site. Is that correct?
Yes.
Okay. And in your review of the zoning ordinance, I'd like to call your attention if you let's see, have your computer, so you can probably bring it up from online. Section 416-45 of the zoning code.
Yes, have it open here.
Okay, and that talks about, locations of signs being prohibited. And it states that the following types of locations are prohibited except as otherwise provided. It says no signs, do you agree that the billboard is a sign?
Yes,
Okay, so it says, no signs may, item B, projected to a required yard or beyond the lot or street line, except as permitted in section, 460-56, you can look that up, but that's dealing with churches and, houses of worship and, schools and things like that. So, do you agree that prohibited means it's not permitted?
correct.
And you agree that this 416-45 is a standalone provision, unrelated to the section where billboards are prohibited townwide.
Yes,
So does this billboard project into any required yard?
yes, the applicant has asked for setback relief.
So that's prohibited. So wouldn't you agree that's a use variance?
I believe it's all interrelated to the D1 that the applicant has sought here, so there's certainly,
That's all, that's not my question. You, in your direct testimony, you called out and delineated two separate D1 variances. You didn't say all the D1 variances, maybe in your testimony, you moved up all your expert testimony in support of the two D1 variances, but you did not say that, no, we have a bunch of D variances and they're all grouped together, right? You made two distinct D1 variances out of just, is that correct?
correct.
So my question is, the prohibition under this section of a sign billboard in a required yard, would you agree that that's a use variance required?
I think that falls within the umbrella of a blanket prohibition of the use altogether anywhere in the community, not just in a yard, but within a building envelope as well. There's an overlap here between this section of the ordinance and the overriding prohibition against billboard on any patch of ground anywhere in the community. These are more specific locations that signs are prohibited.
Your testimony is that these are subsumed into the townwide prohibition.
Yes,
So, but we're talking about signs. We're not talking about billboards here. So you're saying that if this is swept up in the overall prohibition, that a sign for a business, that is, on a particular piece of property advertising that business would get swept up under the billboard prohibition?
well, you're reading or referring to section 416-45, which talks about locations prohibited. Right above that, 416-44, it says prohibited signs, billboards. So I think the two closely tie together. And this next section, 416-45, may actually be referring to accessory signs more specifically, because the blanket prohibition is covered in 416-44, right above that.
Then why isn't it listed in A?
Why is it listed in A under 45 or 44?
Under 44, it says, under 44, prohibited signs and lighting. The following types of signs for artificial lighting are prohibited, and it's A1 is billboards.
Yes,
That's a very distinct, definitive statement.
yes,
And then it goes on and it's, everything that's prohibited is A1 through 10, I believe it is.
yes,
And that's the types of signs and locations that's prohibited, is that correct?
yes,
And but B is focused on, I'm sorry, section 416-45 is specific as to locations.
well, again, I think the greater location is covered in the town-wide prohibition under 44A. There is certainly an overlap there, but I think the greater umbrella is the community-wide prohibition, which again, I think overrides or supersedes the need for the double relief. One covers the other.
So if this was, just a hypothetical, if this townwide prohibition was challenged on constitutionality basis, and the court decided to throw the townwide prohibition out, you're saying the town should also throw out the location provision?
We're gonna check, though, I think we can answer.
The applicant is asking relief for setbacks, front, side, and rear. So if 44 were thrown out, could the community still enforce 45? I don't know that answer. I'd have to chew on that a little bit.
Okay, that's fair. And then same line of questions, and we don't have to belabor, just to put on the record. 416-45, item C says signs, a billboard being a sign, it cannot extend above the roof of any building. And would you agree that this billboard extends above the roof of, one of the principal building on this?
It certainly is higher than the roof and it extends above. I don't know if that means affixed to the rooftop, or if that's implied. But yes, that could apply as well.
Well, you raised some doubt there. I don't want there to be any doubt on the record. You raised some doubt. You didn't know if it was, kind of supported by. So let's read C. 416-45 C says signs be placed, inscribed, or supported upon the roof, which that's probably not the case either, right? Or upon any structure which extends above the roof of any building. So they make a this provision makes a distinction, or actually categorizes both. It could either be, if it's supported by the roof, it's prohibited, or if it extends over the roof line, it's prohibited. Do you agree?
Again, I'd like to chew on that one a little more. I'd have to dive into the language a little bit more. I've actually seen signs where the support actually go through the building and or above the roof, and so I don't know how that would be interpreted. I'd have to think about that one.
Okay, but you also believe that, and I don't put words in your mouth, that you also believe that this prohibition of signs over the roof line would be swept up into the general overall provision of the prohibition.
Yes, I think the townwide pretty much covers everything.
So if I had a sign that extends over the roof, forget it's a building. If I had a sign, it's not hypothetical. If I had a sign that extends into a setback or over the roof, what type of variance can I be?
So if I had an accessory sign for a business that was a flag that can't deliver over the roof, and let's say it's a one-story building. I'm reading the words, which I'm sure were carefully chosen. I don't know that the language is there that would prohibit a flag sign over a rooftop. To me, the words be placed, supported by the roof or any structure is a prohibition against being attached to the roof. It could be interpreted otherwise, but I don't think it's clear cut one way or the other.
Okay. So you're familiar with the Price case, Supreme Court Price case?
Price of Medji, yes.
And that there's a number of cases starting with Medici, but the Price case may be the most recent, but that the standard here, what we're talking about is the promotion of general welfare because the site is particularly suited. Is that correct?
Yes.
And for the particularly suited aspect, the testimony was that this was a particularly suitable site based on the location in proximity, because I'm not sure if it's actually fronting Route 4 or not, but in close proximity to Route 4, visible from Route 4, in relationship to, other properties in River Edge. Is that a fair summary of your testimony?
Yeah, my understanding of this Price versus Himeji case is that the board and me should consider the physical characteristic of the land and the context in terms of its suitability to accommodate physical characteristics.
The physical characteristics. Also the unique characteristics, right? Of the land.
I'm sorry.
The unique characteristics of this particular site?
I don't know that particular suitability, in fact, Cox talks about it in his book, that to be particularly suitable, it does not have to be unique or the only site, but it has to have attributes, and again, this is my interpretation of Price versus Himeji. Physical attributes that accommodate the use, that are suitable for the use.
Okay. And, actually Cox, does talk about it being the unique characteristics of the site. That's right, actually, it Cox.
It's probably a question of law or interpretation, but my understanding of site suitability was it did not have to be the only site that was available or had attributes that were the only site in town.
So again, you're talking about this site, and I don't know your testimony, this site as it relates to other sites. But we're also have to focus on this site in itself, whether the site itself is particularly suited for the proposed use.
Yes,
So, and I'm assuming your obviously your, opinion was it is.
yes, I said by virtue of context and condition.
Okay.
I could elaborate if you need.
So we just talked about two prohibitions, outright prohibitions about signs encroaching on into a yard setback and being over a roof. Two express prohibitions by the town's code. And you're saying the site is particularly suited, notwithstanding it violates two express prohibitions?
It's, land use is all about the balancing.
No, that's not that's the C variances. We're talking about the use variance. We're talking about particularly suitability. We're not talking about balancing yet.
I'm talking about site suitability based on the fact that you have a community that has one main road in the southern portion. This is a land use that follows our road patterns. The applicant didn't put the road there, road was there. This is a land use that naturally follows. That goes towards the context. We start there. Then we look at a pocket of commercial or non-residential uses, which this is compared to the rest of Route 4, which is more residential uses. It's only about a half a mile here in the community, so there are very limited options. I think the applicant has looked at a site that has suitable characteristics, particularly suitable characteristics, based on that context, notwithstanding the fact that there is a violation of prohibition against certain height and locations on site. In my view, that's looking at the whole application. And then, of course, in terms of suitable by virtue of its condition, that this can retrofit on the property without having to move or alter anything else.
Okay, so from Price makes a statement, the Price case makes a statement that says it's an inquiry into whether the property is particularly suited for the proposed purpose, in the sense that it's especially well suited for the use in spite of the fact that it's not permitted. So that statement in Price is not talking about the one factor that you're talking about the different properties along Route 4, and this one, in your opinion, is the only one that's suitable for it. But that statement is talking about the site itself. Do you agree with that?
I'm sorry, I didn't follow the question.
Okay. Well, this is a statement in the Price case.
Yeah.
It says fact specific and site sensitive inquiry. It's an inquiry into whether the property is particularly suited for the proposed purpose, in the sense that it's especially well suited for the use, in spite of the fact that it's not permitted in zone. So do you agree that Price is saying we have to look at site specifics.
We just want to object that you're asking for his interpretation of the law, but he can answer.
And I'm sorry, that was actually direct quote, so that was not my interpretation.
You're asking for his interpretation of the case.
No, I'm asking for, does he agree that that's the
He
standard,
says
that's
it?
the standard?
Just so everybody knows, remind board, board is quasi judicial, board will determine what the law is. Pretty common objection is to object to, asking witness for legal. Legal opinion is what belongs to the judge. Judges don't like to hear legal opinions from lawyers, the judge. In this instance, you offer the judge, so. Three towns experience, all towns of their experience, biggest boards for the experience, so we'll take whatever answers Mr. Dunn wants to give, but the board is going to interpret.
Well, all I can say in response to that question was, my understanding of this Price Mickey case is that site suitability is fact specific, it is site sensitive, and I try to give the board the facts that I think are the reasons why the site is suitable. Again, those textual reasons and those condition reasons, and I won't go through them again, but I've tried to make it fact specific.
So the size of the site is 18,000 square foot and change,
Yes,
and the minimum lot area is like 15,000 square feet, I believe, in the C2 zone.
I believe that's correct, yes, so it's slightly undersized for the zone.
Undersized or oversized?
Slightly oversized for the zone. It's a 18.5 thousand square foot lot in a 15,000 square foot zone, so it's slightly above the minimum lot size requirement.
So it's about 3,000 change oversized.
That's correct.
And that could be a good argument to say, hey, this site could accommodate two principal uses. Is that correct?
It could, yeah, that there's spatial capacity there to accommodate a second use, especially one that's relatively small from a ground coverage standpoint.
So if the site's oversized and could accommodate two principal uses, why does this site have to violate two prohibitions in the township limits? Encroaching on a setback and being over the roof.
Well, it relates to the shape of the property. It's an irregular L-shaped property. And also to the condition of the property. It's a developed piece of property with a building already on it, and the applicant is asking the board to move on a sign that's located in a pocket on the site where it's away from the building and does not interfere with site circulation or site parking. Again, it's in a yard, but it's out of the way in terms of circulation, parking, and building.
So do you agree that in order to do a use variance, you also, the second prong, you have to also prove what we call the enhanced quality of proof?
I do, yes.
And I reviewed your testimony, and I didn't see anywhere where you, on direct testimony, you talked about the enhanced quality of proof in terms of trying to reconcile the exclusion of billboards, whether it's in this zone or townwide, with the master plan. Is that correct? That was not in your direct testimony?
I-
I don't want you to testify now.
Yeah.
I'm just saying, I'm asking you, did you cover that in your direct testimony?
I thought I did, but maybe I did not. I thought I referenced the 2020 master plan and some goals in there, but I know it was the very end of the night, so maybe I didn't.
Well, did you reference the goals in support of the special reasons, or did you reference the goals to reconcile the exclusion? That's the difference. Do you agree?
I do. I may have gone through master plan objections, but I may not have gone through the actual reconciliation of the fact that assuming all the things I said to the board agrees with and thinks it's a good fit here, we still have to reconcile the fact that your governing body has said the use is not allowed here in the zone or anywhere.
Right.
And maybe I
that's a
didn't address
critical part of the proof for use variance. So that
I
one
tried
of
to,
the elements. Do you agree?
I tried to tie it back to the master plan, but yes, again, in my view, it would relate to the distinct characteristics of the site. It's almost circular with the particular suitability argument for the reconciliation.
And for the promotion of the general welfare, I believe your testimony was really focused on the communication aspect of the sign.
Yes, it's a tool of communication, yes.
And it's a static sign.
It's a static sign, yes.
And so at any one time, whether it's for one day, 1 month, 1 week, 1 year, it's going to have one particular message on it.
Yes, that's correct.
So it's not, and if it's for, and it could be for a public benefit, but it also could be to promote a business. Is that correct?
Yes, yes.
And
Either,
if it's to promote a specific business, that's not promoting the general welfare. Is that correct?
I don't know that that's true at all. Our state regulations for outdoor advertising talk about the need for this, or statewide regulations that govern this land use, talks about the need to stimulate economic activity and how it's an important tool of business, which is good for the state as a whole, which is, in my view, includes the general welfare.
So every business sign promotes the general welfare. Is that your testimony?
My testimony is that this sign, as a form of communication, can provide messages that will certainly promote economic development, stimulate business, jobs, and the like. So,
Even though one business isn't being advertised at any particular time?
yes,
Okay,
Yes.
that's fine.
that's my testimony.
And I think you cited, to support your testimony, the Bell v. Stanford Township case. I think that was the case where you cited.
Yes,
And that case was really about the constitutionality of an ordinance. Is that correct?
yes, I think the words I use, at least my notes say, our courts have made clear that the use is a form of constitutional free speech, and I refer to the Bell versus Stafford case.
But that case does not talk about, in any way, shape, or form, the promotion of general welfare.
I don't know, I don't know that. If it's not in there, I'll accept it. That's probably a question of law.
Well, no, well, you know, it's, all we have to do is read and look for general welfare.
Yeah, I don't know.
So do you agree that the purposes of the municipal land use law are special uses?
Yes, those 18.
And do you agree that the Medici case says that only special reasons that promote the general welfare can be considered?
I think it's any one of those 18 or so purposes of zoning. One or more purposes of zoning have been found to promote the special reasons or satisfy the special reasons test.
Well, I'm not talking about promoting the special reasons. Again, we're talking about a use variance, right? That the general welfare has to be promoted because the site is particularly suited.
Yes,
So
okay,
we're talking
yes.
about general welfare. So are you saying that any of the purposes of the municipal land use law promote the general welfare?
No,
Okay.
no.
You promote, I agree they promote the special
I
reasons.
agree with what you just said. Yes.
Okay, so you mentioned a few of them very quickly, yeah, maybe going back and front. You cited item M, which deals with, you mentioned item M, this is the purposes of municipal land, so you mentioned, item M, and the only thing you mentioned there was more efficient use of land.
Yes, that's usually the way I paraphrase that section is, purpose M. The promotion of efficient use of land with the goal of lessening the cost of construction is the way that the greater section reads.
Okay, but your direct testimony, is there an end clause in there, like 1 and 2, or item A and item B, but you only testified that, about the more efficient use of land, which was one of the two components of that section. Is that-
That's
Okay.
correct, yes.
And then you testified, and you piggybacked off of Mr. Smith's testimony, about, the, free flow of, traffic, item H.
Yes,
And is it really item H, purposes of the MLUL, to encourage the location and design of transportation routes?
yes.
So
Always.
how is this billboard, you talked about item H being applicable and actually promoting the general welfare? How does this deal with the location and design of a transportation?
It's probably out of this, all the special reasons I gave, perhaps I'll say the weakest or the thinnest. It was, one that I put in there because it is providing for a communication device along a transportation route. There is a nexus between primary arterial roadways and this land use. It's a way to reach the greater good with messages. But I would agree, it's probably the weaker of the special reasons that I gave.
And when you, I think your testimony was that you, actually visited the site
Yes,
in the neighborhood?
yes, they and tried to see it at night too.
Okay. Did you walk around the neighborhood?
I didn't walk around the neighborhood, but, I observed. I didn't actually get out.
Did you happen to observe my client's property?
Yes,
Uh,
that's the one behind, right, with the signs for, new, it's like a real nice development back there.
okay. So you saw the sign,
Yes,
say come soon or whatever it says.
yes, yep, looked to me like a multi-story, multi-family, maybe mixed use.
So when you saw that sign and preparing for your testimony, did you review the approved site plan and architectural plans?
I didn't actually dive into them. I heard the testimony of the cross of Mr. Simoff last time. I know there is a representative rendering floor plan too, I think, on the actual site. And I know there's a rooftop terrace, and I know there's concern from our neighbor about the impacts.
This application, your client's application requires a height variance.
It does, yep, 60 feet. 60 feet where 35 is the maximum allowed.
That's almost so.
Yes, it is.
And I think you cited the Rosso case in support.
It did.
Okay. So the Grasso case. It talks about what you need to, support a height variance. The Grasso case says, undue hardship, which, do you agree we don't have undue hardship here?
I would agree. No hardship here.
Says, or in the alternative, this is special reasons, by demonstrating that the increased height of the building, we're talking about the increased height being 25 feet,
Yes,
the increased height of the building, or the structure in this case, right? For the height restriction, which the court characterizes being focused primarily on light and air concerns.
yes,
Your testimony to support the height variance was limited to the fact that, oh, anybody on the rooftop amenity is not gonna be looking at the messaging. You're looking at the back structure. That was your testimony. You agreed?
yes.
You didn't address the impacts to the light and air, which the Grasso case says you need to support for a height variance. Is that correct?
I think I touched upon, shadow effects, scenic views. All I think are related to light, air, and open space.
You touched on shadow effects.
I have them right here in my notes. If I didn't, I skipped
So
past
did
them.
you do a shadow study?
I did not do a shadow study. Again,
How far off of the, what's the distance between the billboard and the rooftop amenity?
it is, now, I don't know if the building is set back from the property line, but I'll just say that the billboard is set back 17.8 feet from the common lot line with your client. I don't know if the building's set back or on the line.
So, and, I'll take your word that it's included in your notes in terms of shadow effect, but if you did no study, you have no data to support I'm assuming your testimony doesn't really have a shadow effect, was that your testimony?
Yeah, it would not have a yes, and, well, the reason why I would have said that is, again, it's not a boxy structure. It certainly does have mass up top. But it is, it's a roofless structure. It's not as bulky as a building.
So we're talking about the air and light impacts,
Yes,
not only the rooftop amenity, but to the building itself, the occupants in the building.
Yes.
So will you, without any data, studies, shadowing, would you agree that your opinion's what they call a net opinion?
well, I think the facts will support the fact that this is not going to be, this is a sign on a pole. This is not a building. Therefore, it is not going to cast the same type of shadows that may be associated with a boxier structure here.
The prosecution case doesn't distinguish it, you said same type. Prosecution just talks about air and light, doesn't characterize types of shadows. Yeah.
So with the Grasso case, I thought I put these comments in here because Grasso actually talks about that. Blocking scenic views, creating negative shadow effect, population density that it needs to be happen. I spoke about all of these. That's
So you talked about and testified that you looked at the master plan and you cited the number of the, I guess, potential goals and objectives of the town's master plan.
yes.
Did you mention, what's that called? It's actually in the zoning code, it's not in the master plan. You looked at the purposes of the zoning code also?
I usually do,
I
yes.
think that might have went to sleep again. Is present, hold it. But it's blinking. Sounds like it's working.
Okay, so purposes of the Borough Zoning Code 416-3A is to promote the orderly development to protect and enhance the character of the borough of Riverbridge through regulations and uses of land. Was that one of the purposes that you cited?
Yes. No, I did not cite any of those purposes at the DP. These purposes that are at the preamble to the zoning ordinance, many of them echo what we see in the MLUL, so I probably did hit some of them, but this A is different than what we see in the land use law.
Okay. So you didn't testify how this billboard a second primary use on the property that violates the prohibition of going over the roof and violates the prohibition of going into the side yard, actually protects and enhances the character.
Might have to have you move to this microphone. That one might have died, but.
Right.
Okay, so did you provide any testimony in terms of how the billboard will protect and enhance the character of the neighborhood?
I'm not sure if I did on direct or if somebody asked me or not, but I know somewhere along the way I mentioned that maybe they've thrown out a number of, the majority of the town north of the site, 98% is residential. This is a very small pocket in the community along a commercial corridor where you invite activity and signs and business. So I do not substantially see this eroding the entirety of the character of the town, which again is predominantly residential to the north, and this small commercial pocket with this additional message.
Okay. And C, item C of the purposes is to, I'm going to read it, regulate the location of buildings, which is not building, but it's what we call the structure of building, and limit and restrict buildings and structures to designated districts designed for residential, commercial, public, open space, or other uses, and specify standards to which such buildings or structures shall conform. So if you're following along, right, that's verbatim, that's a purpose of the zoning code.
Correct.
So do you agree that this application does not advance that purpose? Because it does not adhere to the standards of the structure being assigned as it relates to encroaching on the setback and being over the roof line.
The intent of that regulation, that statement, I should say, is to establish standards to guide development. But it doesn't impose on the board to deny a variance just because it's a variance. There's a whole nother layer of evaluation that goes into that. So that's based on the facts, the evidence, the testimony that this applicant has attempted to give you to support that the spirit of that regulation is not being violated here. That care and consideration have been given with respect to the location and the placement of the board on this site, which is really the intent of those regulations.
And E is to provide, again, purposes of the zoning codes to provide adequate light, air, and open space, which is really the Grasso case, is that correct?
Yeah.
Are you familiar with the appellate division case called Elko v. R.C. Maxwell Company? It's 292 NJ Super 118, 1996 appellate division case, which is a billboard case.
292 and 118.
118,
118?
118 appellate division 1996.
I need a refresher on that one. I need to know the name's not ringing a bell.
Okay, but it's one of the more prominent billboard cases.
Okay.
That's why, since this is a billboard application, I don't know if you had the opportunity and I think, and I'm not gonna obviously ask you about it if you didn't have the opportunity to review, and that's fine. But with that, there's two strong statements in that case. You can look it up. Even though I know your testimony was about the DOT policy of, looking for billboards and all, this particular case, which is, not that old, 1996, at page 133, and the quote says, "There is no strong state policy encouraging the development of billboards." That's why I wanted to ask you if, you had an opinion on that. And then second one is looking at the negative criteria. right? The negative criteria being no substantial detriment to the character of the neighborhood or the zone plan. And I know your testimony focused a lot on the highway aspects, is that correct?
Correct.
Okay, and this particular case says the highway aspect is not the sole focus of a case related to billboards. Other characteristics related to the adjacent, in this particular case, was an adjacent marine commercial zone, was important. So I just wanted to, again, call that out, see if you had, were familiar with that case, and because I wanted to question you on those two aspects. But with that, I have no further questions.
Thank you, Mr. Wolf. Your question?
One more objector, did
Oh, John.
you want to go?
No problem.
Not that I'm thinking we can, but be thorough here.
Good evening.
Sorry.
You
for-
have a real too,
This- That was bad, thank you.
Like a friend.
Sorry.
Yeah. Good evening, Deputy Cheney, Connor Foley, on behalf of Route 4 Main Street LLC, State of Cumberland Trustee, and 41 Grand Avenue LLC. Good evening, Mr. McLennan.
Good evening.
Mr. Sarlo hit a lot of things, so I'll kind of be brief with it. First, is the height necessary because of the billboard use?
Yes, the height is necessary to effectuate the use, yes.
Okay, is the height necessary because of the site?
If the site plays into, comes into play for sure, because there are other structures in the area, there are moving vehicles, utility poles, trees, all sorts of things that call out the need in the landscape for the billboard to be at the height that it is.
So then how can it be necessary because of the use?
The whole purpose of the use is to be viewed by the motoring public. So for the use to effectuate its purpose of being visible to the motoring public, it needs to be at a certain line of sight where the motoring public can see it. And there are other obstacles related to the site, related to the landscape, related to the surroundings that are calling out why it needs to be at that height.
So a billboard standing alone doesn't need to be the proposed height, but a billboard at the given site needs to be the proposed height.
Yes, I think you can certainly point to the site and the area as the reason for the height. Yeah, we see billboards at ground level in many locations.
So the proposed height is not necessary for the billboard use then?
In my view, it's necessary to effectuate this. The use would be rendered useless if it didn't have the height, because it wouldn't be visible. Drivers wouldn't be able to see it.
Well, drivers would certainly in the internal corridor, so some drivers would certainly be able to see it, correct?
It would not effectuate its purpose, in my view, to provide clear and safe visibility to the motoring public. There's too many things in the way if you go low.
Are you aware that the board conflict attorney issued a July 7th, 2025 guidance to the board to instructing them to, or recommending them to turn away from the D1 prohibition?
The attorney or the engineer?
The board attorney. What,
I
wrote him out.
Okay.
And I wrote a subsequent. I don't know if you ever seen
Right now, I don't recall seeing it.
if the board was encouraged to, and understanding that you did not see it, if it's easier for the record, I'm happy to read the portion that I'm referring to.
I would just be careful with that because I did issue a subsequent memo
Okay,
after I did more research.
okay,
And I kind of changed my opinion on it. So I don't want
okay.
to.
I mean, just for the record, Charles Sorrell, I don't think I saw that second.
I was never provided with
Yeah.
one either.
I may just share that. we'll get that over to you. We'll just spread it out around. There was a Supreme Court decision out of, Austin, Texas, that had a very similar, sign ordinance to what we have in River. If you look carefully at the definition of billboard, it is, to me, a little bit peculiar, because I think of a billboard as a billboard, you're driving down the highway, you see it. It's not quite the definition of billboard or river. The definition of billboard or river is a sign like that have to provide advertising for goods and services, not on the property. So you could have a sign, with this sign, on this property, it could advertise business taking place on this property, would not technically be a billboard under the definition that we have. And at the time that I drafted my first memo, I was unaware of this Supreme Court decision, which I think was either 2022 or 2024. I apologize. But as I often say, don't be mad that it was came late. Too often it doesn't come at all. So, I revised my opinion and, we'll be happy to get that updated.
Thank you. So with what we just said here, how can the ordinance provisions 416, 44, and 45 be subsumed if they were encouraged to turn away from the D1?
Again, I don't know the substance of that, that legal letter. I'm not sure what you mean by turn away from the D1. How can they be subsumed if they, I don't understand the question.
How can these provisions that you encourage to be subsumed into the broader prohibition be subsumed if the larger, broader provision you're arguing is unlawful?
I mean, we objected to the fact that it's unlawful. I don't think anybody can make that determination, but you can answer it.
Again, I don't understand the question. You know, you saying if they.
Is it a predicate to the ordinances, to the 416, 44, and 45 subsuming into the broader prohibition that is predicated on the broader prohibition being lawful, correct?
I think what you're asking me is if the greater prohibition goes away, which is what Mr. Solar asked, but those two sections still apply. Is that what you're asking me?
Well, I mean, part of it is obviously things have changed a little bit in between when Mr. Solar last and we had some new guidance on the record here. But I think it still stands. Are you changing your opinion based on the fact, do they still subsume?
Again, I must be misunderstanding.
That was your prior testimony, was that they subsumed.
Mr. Sarlo asked me if the ordinance regulations against location 45, 46, I'm in the preamble here, the purposes. 45 and 46 were subsumed within the 45. I thought they were.
Okay.
Okay. I thought they all had, you've got the blanket prohibition in the community. The prohibition against location, and there was another prohibition. I think they all tie together.
Okay. Are you aware of the prohibition under 416-44, 44, and then it's in parentheses 4, which prohibits signs which compete for attention with traffic signals?
I'm gonna get there. You said 416-44?
Yep.
Okay, subsection.
Subsection 4. It's 416, sorry,
Some
416.
signs which compete for attention with, or may be mistaken for a traffic signal.
Are you aware of any traffic lights in the area?
I'm aware that you, I have to look at a map to see where the closest one is. That said, we have sworn traffic testimony by an expert on the road that said that this sign will not cause a traffic safety issue. to me would fall in line with that, signs which compete with, or are mistaken for a traffic signal.
So. Just for the record, you did testify that you did site inspection, correct?
Yes,
So are you aware that there is traffic signals at the intersection of Kinderkammek and Grand Avenue? Kinderkammek Road, sorry.
Kinderkammek and Grand, you mean behind the site?
Yes.
Okay, yeah, I just drove it. I can't remember if there was, I didn't really consider it because it's behind the sign. I don't know how the back of a sign would compete with a traffic signal if that's where the question's going.
And then there's additionally traffic signal at Main Street and Kinderkammek, intersection of Main Street and Kinderkammek Road.
On the other side of the pedestrian bridge from the site?
In the general area as well as Kinderkammek and Grand Avenue.
Yes, I know there's a signal there, yes. I have heard no testimony that this sign will conflict with visibility of that signal.
Okay. How can the billboard further the purpose G of the municipal land use law, sufficient space and appropriate locations, if the ordinance outright prohibits billboards and then further prohibits billboards that extend above the roof of the subject building?
The way that purpose is broken down is a variety of uses in appropriate locations. Again, I fall back on the fact that we are along the highway to give the message to the traveling public according to the needs of all New Jersey citizens, and that's what these message boards do. They talk to people. It could be of medical use, and that may spark a familiarity for someone or an interest in someone who wasn't aware that was there. So again, it's a form of communication to make people aware of something that may not actually be on the site. But
Even when the ordinance says, no, that's not an appropriate location, by specifically saying generally outright, but also saying extend above a roof.
yes, again, I think that's part of the site-specific analysis that the board needs to consider. The facts that the applicant have given with all the visuals and the evidence and the testimony, that notwithstanding the fact that it is a variance, that the belief is justifiable because it provides for use in an appropriate location according to the needs of all New Jersey citizens.
How can the billboard further purpose H of the municipal land use law, promoting free flow of traffic, absent testimony the billboard increases efficiency of traffic?
Well, I lowered that one a few notches when Mr. Sarlo asked me. But again, there's a nexus between the motoring public and the fact that we are on a highway. Typically, we would use that more for a digital billboard where you may have some form of real-time messaging that talks about a traffic problem up ahead. But conceivably, there could be some sort of notice to the public as well related to traffic. So it's a lesser, I give it less weight than the others, but.
So you'd agree that no impact does not equal a positive impact?
No impact is not, well, typically when we do the positive and the negative criteria, absence of negative criteria would in and of itself be a positive, in my view.
Brian, how can the billboard further purpose M of municipal land use law, creating efficient use of land? Again, where 416.44 and 416.45 B and C prohibit the use outright, and also for those specific reasons among.
Well, I like the fact that this does not require any alteration of access points into the site, drive aisles. It's in a relatively, open, unpaved area of the site. And it's a retrofit, so I think that goes towards our planning goal for efficient use of land. We have scarcity of land in here in New Jersey. We run out of land, so we have to pick spots to repurpose and reuse.
Nothing further, thank you.
Thank you.
Our professionals,
Try not to be too redundant and, cover what I think we must. McDonough, how are
Good evening.
you? Just because it came up, I'm gonna start with the question of, what Mr. McDonough deemed as the blanket prohibition of billboards in River Edge. And just to be clear, what, is it your testimony, Mr. McDonough, that municipalities can't prohibit billboards or off-premises signs under any circumstances?
This is my interpretation.
Just object for this being a complete legal conclusion, but.
My understanding, because I've seen it done, is that flat out bans on billboards, is certainly grounds for a challenge. And
Under certain circumstances.
yes,
Okay.
it's probably more of a legal question, but yes.
The Austin case was raised where the United States Supreme Court sided with the municipality who had an off-premises sign prohibition similar to the boroughs. There's also the municipality of Mount Laurel, which is in New Jersey, has a similar off-premises sign prohibition that was upheld by the state Supreme Court, is my understanding. I think the year was 2013. So you have the state and national level Supreme Court cases that have upheld similar prohibitions against off-premises signs. So, the ordinance calls it a billboard, but really it can be characterized as a prohibition against off-premises signs. And I think those types of prohibitions can be distinguished between signs that regulate content. And I would agree that signs that regulate content do violate the First Amendment. And I think that's a critical distinction, where you can regulate off-premises signs, but you can't have signs that are not content neutral, that are not content neutral. And that it's been upheld numerous times that municipalities can have sign regulations that address time, place, and manner, and time pertaining to when signs can be illuminated, for instance, place, referring to location, whether or not they're off premises, and manner. And I would offer that even if it were held for some reason that this prohibition was deemed to be invalid, would you agree that that doesn't automatically render the billboard a permitted use in this case?
If the prohibition was deemed to be invalid,
Right.
does that mean that this site is automatically appropriate? No, it doesn't, yeah.
So not appropriate, would it be deemed to be a permitted use in the zone? So even if
No.
you overcame the prohibition, does that
No.
automatically mean this is permitted on this particular piece of property?
As I understand the law, again, that's probably another legal question.
Okay,
As I understand the law, no, that's not an automatic.
okay.
uh,
So in that case, as I believe you've correctly done, you've addressed the applicable Medici case law for a non-inherently beneficial use and the applicable statute, site suitability criteria, which we've gone through to some extent.
Yes,
And just in closing, while we have a prohibition, it's also the case that towns don't have to permit every available use under the sun. Is that accurate?
that is accurate.
Right. So even if we didn't have a prohibition against billboards, we wouldn't have to allow them anywhere. That's not a requirement, right? We wouldn't have to say billboards are necessarily allowed in any particular area.
Just want to get on the record, this is a legal conclusion, he doesn't have the expertise to make
Based
that.
on your familiarity of municipal land use law and case law that planners are regularly relied to testify upon?
Could you just give me that question one more time? 'Cause I
Okay.
want to process
Yeah,
the
that was a
finer
little-
words in there.
just understand, there is a lot of
Yeah.
overlap between architecture and engineering. Sometimes we stray from one profession into another, so. No one's gonna hold us to a legal opinion, doesn't have black robe. Not a laundry, but he's probably got more case law than most normal.
Okay, let's move on. That's okay. So that was just the issue of the D1. And we would agree that the billboard itself constitutes one, a second principal use, and two, a second principal structure on the property. Is that clear?
Yes,
In addition to the existing office building?
yes,
Okay. Which is a permitted use in the zone?
yes. There's no D2 relief here, or as I understand it, based on my review, for a expansion of a non-conforming use. The use that's there is.
Pertaining to moving on to the D6 height variance that was touched upon. So you mentioned that the height at 60 feet is necessary for visibility. What testimony or documents have been provided to the board that indicates that the 60 feet is necessary in this particular case?
I don't have the actual, I have to get the exhibit number, but I know with these applications, we typically would show views or photo simulations from the road.
Right.
I don't know if they were provided as part of the record. I have to remember the number, but that's typically part of the justification that you see from 500 feet away. You see the sign and you see what's around it and how it integrates with the view shed.
Well, I think there were renderings provided that showed that the billboard was visible from the highway, but I don't know if that was sufficient to indicate that 60 feet was necessary. I don't think we've had testimony or any information that suggested that 60 feet is necessary for visibility. There was testimony that said you needed the height to clear the 3-story building. We did hear that specifically, but again, there was no determination that the 60 feet was necessary for visibility on the highway at any specific point.
I'll rely on the testimony on the record, and the board can certainly give it the weight that it gives it.
All right, thank you. Moving on. Question came up pertaining to the actual road classification. We bounced back and forth. It's been called a few different things. So the site itself seems to have 3 frontages. One on Grand Avenue, one on Johnson Avenue, I believe, and then and
Yes,
then the third being the one in question is whether or not the site is actually on Route 4, whether it's on Johnson Street or whether it's on some marginal road. So that question has been asked a few times now. Have you been able to, or has your team been able to confirm the actual road classification of, in particular, the frontage where the billboard's being located?
I have not been asked to look at that, and in my view, if that strip along the frontage of the property were not Route 4, that's not fatal to the application because that's not a requirement, and that may not have been the question you were asking me, but the answer is I don't know. It may or may not be Route 4, but if it's not Route 4, in my view, that's not fatal to the application. It's not a requirement under the DOT standard.
Not a requirement, but your site suitability analysis is contingent upon the fact or the idea that the site is actually on the highway where it might not really be on the highway. Might be proximate to the highway, but not on the highway. And there would seem to be a distinction there.
To me, it's not a great distinction, in my view. It's not a substantial.
But your testimony was that the site is on the highest order roadway in the borough. And based on DOT classifications, Route 4 is considered, or at least labeled, NJ4 secondary. And this road in question is labeled 2 different ways. It's called Johnson Street, and it's also indicated as a service road where it says from NJ4 westbound to County Road 68, which is Main Street. So there's definitely a distinction between what is the 3-lane portion of Route 4 at 50 miles per hour versus this, I guess we'll call it a service road.
Again, if the word on or along is misleading to the board, I'll swap that out with the word proximate, near. I don't think it's a requirement that it has to actually be on. And I think it's self-evident from the visuals, both from top down, that that this is a sign that is clearly going to be visible along Route 4, which is the target audience.
Okay, so that portion of frontage though isn't the entirety of the site. I think it's about 30 feet is what was testified to. Sort of that corner that's on Johnson Street.
The back corner that's on.
Right, where it's
Johnson
actually
Avenue.
arguably on the service road, where the remainder is on local roads.
Grand Avenue and Johnson Avenue,
Right.
are local roads as far as I understand.
Right,
yes.
but the frontage itself, it's not, you know, like when you think of a commercial site on a highway, it's got 100 feet, there are standards. The 30 feet in this case doesn't meet the borough's lot width standard. It doesn't meet any standard that you would consider for a commercial property on a highway, being that it's only 30 feet of frontage on the service road. And my point is that, would you agree that there's a limited portion of the site that's actually on this service road? We're talking about site suitability, whether or not the site's on the highway.
I would agree with the factual, statement. I'll say that the site has multiple frontages, two of which are local roads, the third of which is a service road, or part of the Route 4 right of way, I don't know, but it's adjacent, certainly immediately adjacent to Route 4.
Mr. Chairman, if I can interject to clarify something. At the first hearing, I believe it was the first hearing, Mr. McDonough, good evening.
Good evening.
Mr. Sinisi obviously was the attorney for the applicant. Your engineer got up, and the question became, what is the frontage? And they held up a piece of paper and said, we have a permit from NJDOT. Like that was gonna be, why are we even here? Why are we wasting anybody's time? Because we have that, which is really meaningless anyway. And I asked a question, and then you came back, not you specifically, and revised the survey. Yet today, we still, to this date, don't know if there's frontage or not. But you said it's not important.
In my analysis, I didn't consider whether it was frontage on Route 4 or not.
So it doesn't matter.
In my opinion.
Okay, it doesn't matter. If the plans are inaccurate, does that matter?
Yes.
That does matter.
Well, I guess it certainly depends on the level of inaccuracy. If it's inaccurate in terms of boundary survey, yes, absolutely.
Let me help you out. They're inaccurate.
They are accurate.
They're inaccurate.
Oh, inaccurate.
There's a jurisdictional map, which I brought up from day one. Yet it fell on deaf ears. The survey that was sent back in, and in order to do a site plan, you need an accurate survey. It's inaccurate. The line that he put on the jurisdiction is inaccurate. He never went back to what's called the jurisdictional map. I don't know if you're familiar with that.
Yes, yes,
Pretty simple.
yes,
Looks like it's done with crayon.
yes.
But what it is in actuality? Who plows, who maintains, who does? And in this case, you have three entities: the state of New Jersey, the county of Bergen, and the borough of River Edge. What's interesting, the jurisdiction goes to the point of tangency, not the point of curvature. So your actual frontage that you claim from day one is not state. It's controlled and maintained by the borough of River Edge. So the maps that were done, the site plans, the surveys are inaccurate. But you just said it doesn't matter.
Well, in terms of site suitability, I do rely as one of the factors, not the sole factor, that this has been deemed to be a quote-unquote permitted location under the NJDOT regulations for suitability and site selection for billboards. Generally, it has to be within 600 feet of a highway. It doesn't say it has to front on the highway. It has to be within 600 feet in a non-residential area. Or right off the bat, you don't get that.
I understand,
that-
but you have that.
So
There's no argument here.
we,
that
we
you
we have it, and the fact that it doesn't front on, in my view, doesn't lessen the suitability of the site. And I gave you other factors as well, even if the board finds that that's an important factor. I've given you other factual reasons.
No, I didn't, again, I missed your testimony. I wasn't here. I didn't want to get divorced, so I was on a cruise for my 30th anniversary, but I'm here tonight and I've listened very closely. Site suitability. So that particular spot, right there, right where you're proposing it, that you need setbacks, height, 60 feet. Just curiosity, 6-story building to the top of it, right?
Yes,
Let's do it in plain terms, 6-story building.
correct.
Highest structure that would be in the borough of River Edge. No shadow study. But you said, it's not gonna cast. What about a fall zone, just out of curiosity, would that impact anybody?
That's really a building code issue. We run into that with cell towers a lot as well, fall zones, that they have to be designed to. Sometimes I get questions about that, what happens.
Well, you're getting one tonight.
Yeah,
You said, this site, it's open, it's here, it's suitable, it's great. Just out of curiosity, fall zone, where would it fall?
well, I don't know, you know, in the event,
60-story, it's a 6-story building.
right, I mean, it
That's
could
10 foot
fall
back.
anywhere around anywhere around the clock. It could
Okay.
fall on the roof of the highway, it could fall
It
backward.
could. So that would be suitable?
Well, again, this is all subject to, construction code requirements.
So structures never fall. Is that what you're telling me?
Well, you could say that about buildings and
They
all
never-
sorts of
There's
telephone
never,
poles.
well, let's not get to the poll yet, because that was gonna be the next thing.
All I
At
can say
35
is,
feet, because this is 14, I believe, by 48. So if you push that down, let's say first time, because you said something very important when Mr. Sarlo was cross-examining you. There is no hardship here, right? What would be the hardship?
the hardship to lower the sign I'm not, there's no hardship here.
I happen to be the engineer in Pagoda. There's a billboard. Do you know they put the billboard through the middle of the building on Route 80?
I did that one.
You did it.
Yeah,
So why, right now, you could set that back. And you could technically put this billboard through the middle of the building, have it project through the roof and put it there. And probably meet your front yard setback, your side yard setback. It would be within it. But what would be the hardship? It's self-created, isn't it?
all I could say is that building in Pagoda was a warehouse to store luxury automobiles, so it was very easy it was an open floor plan. Here you have an office building, I don't know what goes on in the guts of a building that would allow for something to pierce through the roof here. That was a very easy building to do that. So
So you're saying structurally somehow you couldn't do it, or?
I don't know. I really didn't assess whether it could go through the building as opposed to where it is. I did not assess that.
Right. Now, if you brought the height down, 35 feet, right, is allowable in the zone, I'm pretty sure.
Maximum permit.
And you have 14 feet, so 35 minus 14, that would be the bottom and the top.
Yes,
And you said there's too much stuff in the way. Telephone pole. Telephone poles, just out of curiosity, what's the diameter of the telephone pole?
2 feet, maybe
Little less.
18 inches.
There you go.
Okay, 40 feet.
So an 18-inch telephone pole is gonna block a 14 by 48 billboard. And it's gonna be completely blocked out, and I don't think it was Mr. Sarlo, I apologize, I didn't get your last name.
Cheney.
He actually questioned you a couple times, saying, so it can't be there because of the obstruction. Now, an 18-inch diameter is gonna block the 14 by 48, and you can't have it there.
Well, that was, it's a saturated landscape. It's probably the best. There are a lot of things there, not just the utility poles, but there are.
Maybe you wanna go on Google Earth, because I go past there probably every night for the past 38 years, but there's not much there. Here's something else you said, and maybe your team doesn't know or not know, the pedestrian bridge. Any knowledge what's going on with that bridge from the NJDOT?
I don't know at all.
But it's important, wouldn't it be? I mean, you brought that up in your testimony.
It's there, I don't know if
Well, it's there today. You know if it's gonna be there tomorrow?
I don't know the long-term plan for that bridge. Don't know.
It's public information, just, I'll put that on the record. I'm sorry, I just wanted to clarify a few things, Mr. Chairman.
Thank you.
Yeah, I didn't mean to take.
No, you're on a roll, without a stop with, so. All right, I'm just gonna continue with the line of questioning with the permit, is gonna be my next question. So you do have the NJDOT permit, and that really focuses on, you know, their jurisdictional criteria for spacing and proximity to highway ramps. That's kind of the crux of their criteria, as far as I understand it.
Yes,
And one of the spacing requirements, in addition to safety, so you're not looking up every, you know, so many seconds, is has to do with aesthetics based on the Highway Beautification Act. Is that your understanding?
yes,
To minimize visual impacts and visual clutter, as sometimes can be referred to?
yes,
Okay. And in this case, you're only allowed to have a static sign because there are two existing double-faced digital billboard signs about 1,000 feet from the site at the border of River Edge and Hackensack.
to the
Got it.
west, to the.
It's in the
west,
easterly
the
direction
east, okay,
at the border of River Edge and Hackensack.
yes,
Okay. So again, you can only have a static sign because you have those two there. Okay. And to be clear, the NJDOT requirement is really only a minimum spacing requirement. Is that accurate?
that
Because
is
you just have to
accurate.
be at least this far, right?
Correct,
Okay, but the permit does also require municipal approval. Is that accurate?
always,
Right.
yes,
So you have to meet a town's zoning requirements, building code requirements, all other aspects of the municipal regulations.
100%. And if somewhere along the way, I think Mr. Costa may have said, just because we're waiving a permit from DOT doesn't mean that takes anything away from this permit.
And municipalities, based on their local knowledge, are able to establish additional reasonable spacing requirements. Is that accurate?
That's correct,
Okay. In addition to setbacks and other location considerations?
yes,
Okay, so it'd be reasonable for a town to perhaps increase setback requirements potentially
correct,
above and beyond what DOT requires.
yes.
Okay. And finally, the DOT permit doesn't really look at, well, I'll phrase this as a question. Does the DOT permit take into consideration surrounding land uses and impacts?
The DOT regulations, again, require that it be in a non-residential area within 600 feet of the highway.
Right, but, you know, one of the issues that was brought up is that there was an office building that's a permitted use, got site plan approval, presumably will move forward with permits, and that there's a billboard in close proximity to their rooftop amenity. So the DOT permit wouldn't have anticipated that potential impact. Is that accurate?
100%. I agree.
Okay. Moving on. We heard some testimony from your team's traffic engineer. One of the questions that I asked is whether or not his analysis considered the impact of other signs within proximity to the billboard as far as competing for attention. Is that something your team has been able to take a look at since his testimony?
Could you say again, proximity of this billboard? to-
Are there
on-premise?
other signs in close proximity to the billboard that would compete for attention? The reason being, he said that there's a national study, I forget the name of the study, but the one that gets used, you know, it says that the average driver glances, or the average glance is 0.335 seconds at a billboard. That gets a little complicated though in urbanized area. You know, that's one thing if you're off on the turnpike and there's nothing for miles, right? It's a different thing when you're in an urbanized setting and there are other signs where there are highway signs directing traffic, where there are other signs on a building on the same site, where there are other signs on other sites in proximity to the site in question. So the question is, was there an analysis that looked at other signs in the area and to the extent that they might compete for attention?
I believe the study you were talking about was that Pentala study that they always talk about with the glances.
It was some independent, you know, I'm not contesting the findings of that, but the question is, you have to be able to apply that in the real world, right?
Yes. I did not do a detailed analysis of, other signs in the area. I'm looking at a Google Street View. And it's generally a commercial area as opposed to a retail area, mostly offices, mostly. I know there's retail in the area. But in the close proximity, I don't see an abundance of signs that this would compete with.
Okay, but the building, which is on the property, has two signs itself, right?
Yes,
At the third story level, which constitute pre-existing non-conforming signs already, is that accurate?
pre-existing non-conforming
Well,
signs,
well, do you acknowledge that there are two existing signs in the
that I
building?
do, I don't know the.
Would you accept that at 3 stories, based on the location criteria that was referenced earlier, that they exist as non-conforming signs?
Yes,
Okay. In similar proximity to that pedestrian overpass that is almost adjacent to the site, there is a highway traffic sign that provides, I guess, the motoring public direction, whether or not, or how to use that ramp, that's the marginal road that's adjacent to the site. Are you aware of that
sorry
sign?
about that little split that.
No, I'm talking about the big green sign.
Oh,
yeah,
yes, I
right in
see
front of
it.
your site, yeah, okay. And at least viewing the site from going in the westbound direction, there's also a Total Wine site and signs from that commercial development that can be observed at the same time that the billboard could be observed. That's something you guys were able to take a look at.
Those are state signs, and I honestly don't know if, separation from those types of signs is a requirement in the regulations. Again, I'll fall back on the fact that it's been deemed to be a permitted location by DOT. And I honestly don't know separation from highway signs, directional signs, is a regulated standard.
But I don't, my line of questioning didn't have to do with the separation, but more for the competing of attention when drivers, are arguably supposed to be looking at the road. We understand that, glances less than 2 seconds might be safe moving at 50 miles per hour, but if you're looking at a number of things moving at 50 miles per hour, that in theory, that could be distracting.
I really have to fall back on the testimony of a licensed engineer sworn under oath, traffic engineer, that this location will not create driver safety or distraction, and I trust that includes consideration of all the signage and other factors in the area.
All right, thank you. We'll move on from that. Then finally, just regarding the traffic engineer, I know you're not the traffic engineer, but has your team prepared or reviewed any accident reports in the vicinity of this?
That would have been part of Mr. Simoff's testimony, and I honestly don't remember if he did. Sometimes he gets asked that direct question and he'll provide that for the board, but I don't know if that was part of his direct.
So
I don't know.
I guess based on that missing information, though, can we really conclude that the billboard would be impact-free from a traffic perspective?
I think the board can give the weight that it gives it of again, testimony of a licensed expert sworn on the road.
Okay, moving on. In your testimony, you mentioned that the billboard is benign compared to other uses that are permitted in the zone, and not to beat a dead horse, but the site is developed with a 3-story office building, correct?
That's correct.
Which is-
May have used the word functionally benign, that it doesn't generate traffic, water demand, sewer demand, that type of thing.
Okay, and again, the office building is a permitted use in the zone.
It is.
Okay, and we touched on the height issue, so the 60 feet, simple math, is almost 2 times the height of the maximum permitted principal building height in the zone.
It
of
is,
35.
yes.
Okay. Regarding the MLUL purposes that you touched on in your testimony that supported the special reasons for the granting of the D1 use variance, you mentioned a few that were covered previously. You mentioned purpose A, which is generally to promote the general welfare. You mentioned that would be supported by a message board that gets changed about 1 time per month. You mentioned purpose G, that it's an appropriate location for the use. You mentioned purpose H, which came up previously about the free flow of traffic, which arguably is not, the strongest of the purposes in this case. And then purpose M, which is the efficient use of land. There are, I think, as you mentioned, as we're all aware, there's about 18 or so purposes.
Yes.
Okay, so in some cases, would you agree that an application might support some of the purposes, but might be inconsistent with others? Can that happen?
Yes, it's an applicant's, obligation to show that it advances one or more.
Okay. Just going back to purpose A, so I understand, you believe that the general welfare is supported by, a message board, essentially, that gets changed periodically. There's a case, it's E&J Equities versus Franklin Township Board of Adjustment. It recognizes that aesthetics are a substantial governmental interest, and in this case, it's particularly in the context, of a billboard. So I guess my question would be that, given that aesthetics are a substantial governmental interest, whether or not purpose A is actually advanced by the introduction of a billboard where they're not permitted. Or whether, maybe I'll phrase it another way, is the billboard an aesthetic enhancement to the community?
I don't see it as being an unesthetic, addition to. I don't know, anywhere where it would say that a billboard is unattractive. I know there's, Scenic America that has, prohibitions against, billboards on quote unquote, what have been designated scenic highways, which Route 4 has not been so designated. So I don't see this as having a materially adverse impact on the visual quality of Route 4.
Okay.
That's my opinion.
But that's fine. And along those same lines, you're aware that the state of New Jersey adopted in December of 2025 its state development and redevelopment plan after, I don't know, 24 years or so?
Yes.
Okay. Page 74 of that document talks about reducing or eliminating signs of visual clutter, including inappropriate billboards. So it would seem to be that there is a state policy that recognizes, in some cases, not all, and what does it mean to be an inappropriate billboard? I'm not sure, it's not defined. But whether or not that relates to the issue of, the general welfare, if it indicates that in some cases billboards might create visual clutter.
That was not a recommendation to eliminate the outdoor advertising regulations, which are still in full force and effect, and allow both static and digital billboards, as regulated by DOT, as stewards of highway safety, and aspects of appropriateness or inappropriateness are left to a forum such as this.
Just going to mention two other purposes. So purpose C, which you're aware of, was touched on briefly earlier, light, air, and open space. Do you think this application for a billboard that's developed with a 3-story office building promotes light, air, and open space?
It goes towards the line of questioning that I think Mr. Sarlo was asking me about, light and air, and the fact that we're in the setbacks and that we're over the threshold of the height that's allowed. Again, it's not a boxy structure. It's got a relatively slender pole and the toppy on the top. So the mass, the scale, I think plays into the consideration of the relief related to height, related to setback, and its impacts on light and air.
And then finally, purpose I, which I think was touched on earlier, to promote a desirable visual element. So same question, does the billboard advance purpose I to promote a desirable visual element?
I think it's a subjective question. One may think they're ugly. I personally I'm not offended by them at all. It's words and graphics on a board. It's information. We see that in the landscape every day, everywhere.
Okay.
There are buildings and other objects in the landscape, so I don't see how the sign, in my view, is any more offensive than other objects we see in other man-made objects that we see in the landscape along this man-made dominated highway.
Moving on, regarding the site suitability issue, is it your testimony that all properties on or near a highway are created equally as far as being suitable to accommodate a billboard?
No.
Okay, so there may be differences where some sites are more suitable than others,
Yes.
along or on or near a highway.
Yes.
For instance, would there be a distinction between, let's say, an industrial part of the turnpike versus perhaps a more suburban area along Route 4?
That really depends. That's a, that's a very broad characterization. Run into a lot of trouble and doing billboards along the turnpike on industrial sites. So it really is, it's a fact-specific question.
Well, I'll bring it maybe more local to just along Route 4. We focus along Route 4, for instance, and we look at where there are billboards in Paramus, Hackensack, Englewood, Fort Lee, and up and down. Would you agree that some areas are more commercial in nature where, you know, they're essentially surrounded by a shopping mall or, you know, further away from, let's say, residential properties than this particular site?
Yes, there's no doubt that there's a juxtaposition of residential and non-residential in this area that may be different than other areas, but that means there are influences on the residential environment that may make this sign less offensive than it may be in another location.
Okay.
There are a lot of factors to consider there.
Well, and to that end, you mentioned that River Edge, and we're aware that it's primarily a residential community. So is your testimony that the board shouldn't consider impacts to the residential community of River Edge or perhaps even in adjacent municipalities, Hackensack, for instance?
It's wide open what the board can consider. I certainly would not discount the residential properties. I will say, as I've said, the back of the V is what would face those homes, and as we start to work our way away from the back of that sign, those homes get further and further and further away till the sign itself becomes not visible.
Has your team prepared any renderings to show what the sign would look like?
From the back,
But, well, not from the back, just from residential properties in proximity to the site.
no.
Would you acknowledge that there are residential properties in River Edge about 550 feet from the site, the northwest?
Yes,
And to the south across Route 4 in Hackensack, that there are residential uses about 450 feet from the billboard, presumably in the direction that the billboard might face?
yes,
But again, so there'd be no impact to, in either case, to those residential properties.
those homes are 450 feet from a highway. So that weighs into my consideration of whether this would be a substantially adverse impact.
So if a residential property is already impacted by a highway, just adding a billboard, it doesn't create any additional hardship to those. We should just say billboards up and down.
I think the board can give consideration to what those homes are next.
Okay, fair. But again, your team hasn't done any analysis or renderings to demonstrate that there would be no negative impact.
Correct.
Moving on to the negative criteria, the zoning purposes of the Borough Code were referenced. I don't need to repeat those. They're in our review memo. We kind of touched on the surrounding land use, and we just mentioned that there's some residential development in the surrounding site. You mentioned a few times that this particular site is in a commercial area, but I think to be more clear, and as one of the objectors mentioned, that really this pocket is more of kind of an office sort of district. Yes, it's in a C2 zone, which allows commercial uses. There are some commercial uses, but the site itself and other developed sites adjacent to this in the borough seem to be primarily office buildings. There's at least 3 directly adjacent to the site,
Yes,
just to be clear. Is it your testimony still that the billboard generates no negative impacts at all?
no, that's not my testimony.
Okay. So what are the impacts?
Well, first of all, any change, any land use application, no matter how large or small, has an impact. It's not the test at all. The operative word in the statute is substantial, and that's what the board needs to weigh. And the impact associated with this sign here would have a substantial impact, but yes, it'll be changed. It'll be an object that's not there now, so that is an impact. It will be visual. As I said, functionally, it's benign.
But-
So it's predominantly a visual analysis.
But even the back of a billboard is not, it's not aesthetically pleasing.
Subject, that's a subjective, we deal with, infrastructure and utility structures in the landscape all the time. To me, it's a subjective question. It's not an object that is unlike utility type structures that we see everywhere.
Are you familiar with the Jacoby versus Englewood Cliffs Board of Adjustment case?
I lived it.
You lived it? Okay.
I tried that.
So-
Okay.
Well, I hope I'm not out of school, but I believe one of the findings, and correct me if I'm wrong, is that the visual impact of structures and buildings can have a negative impact, which not only can, but must be considered by a board determining a D variance, and in this case, a D6 height variance.
The threshold of that case, that was for the LG building over at
It goes to 143 feet, the zone was 35. Nick Seekers came in and said, there's gonna be no impact.
But the point, the moral of the story is that boards should consider visual impact in a D6 case. Okay, that's
Yeah,
the point.
and I think the main thing that came out of Jacoby was the visual impact is not considered only with respect to properties within 200 feet. The board can certainly, towards your line of questioning about the homes. It doesn't have to stop at the 200-foot line, but in my view with distance, I call it saturation, it's not a visual desert there where this object would stand out by itself. You can factor those into the Jacoby question, the test, distance and saturation.
I'm trying not to prolong this, believe me. I'm just going through my standard line of questions.
Run marathons, I'm
Okay, so
ready to go.
Moving on, so you mentioned that you took a look at the surrounding area. Did you happen to do an analysis or consider existing billboards? We'll say near the site,
Yeah, I do, say that again?
an analysis of existing billboards near the site.
There were, I have.
I don't mean it as a trick question. I can provide some of that, then we can talk about it.
Yeah, I think there were billboards, within, about 1,000 feet away.
I'll give a little more precision to that question. So to the west of the site, there's one double-faced digital billboard and two static signs within a half mile of the site. One of those static signs is on the border with River Edge and Paramus on the Paramus side. You may be aware there is one existing static billboard already in River Edge on the other side of the border. It is facing the eastbound traffic. We mentioned the two existing digital billboards within 1,000 feet of the site on the border with Hackensack and River Edge, which is why you can only do the static billboard. And then finally, there are three static billboards about 0.63 miles in the easterly direction in Hackensack. So altogether, there are about 9 existing billboards within 1 mile. This billboard would constitute a 10th billboard within that mile. So I guess the question would be, working with your client as the applicant, what is your perception of the need for a billboard in this location from a public benefit, general welfare standpoint?
Again, it meets the separation requirements of the NJDOT as the stewards of highway safety. It's a permitted location under their regulations. And based on all of the separation standards, it's probably the last billboard you would get along this stretch of work. Given all the other billboards in the area, probably the last remaining pocket that's left.
So if River Edge got its 10th billboard in a mile, we'd be capped, we'd be good on billboards?
I don't think you would be able to get another outdoor advertising permit from NJDOT. I think if we did all the math, this would be the last one.
But again, it doesn't just stop at NJDOT. I mean, we touched on municipalities. Are municipalities able to come up with reasonable location and distance standards?
Again, those are minimums under the DOT standard, but yes.
So can the borough consider that there'd be 10 billboards within 1 mile? Is that something the board can consider?
I don't know how the delta between 9 and 10 would be substantial.
Would the 10th billboard be a benefit to the public?
I believe it would provide messages that the other 9 don't.
Would it be a benefit that outweighs detriments
Yes.
caused by the application?
Yes.
In your testimony, it outweighs the 10th billboard in this case in the manner presented would outweigh any detriment.
Yes.
Okay. moving to the C criteria, or not the C criteria, the variances above and beyond the D variance. It's your testimony that basically all the variances are subsumed under the D one, including the D six.
I think the board can consider the entire package as one thing, yes.
Okay.
Yes.
Just as a point of reference, locally, I would offer that the static billboard directly across Route 4 and River Edge, I would say is about half the height of this billboard. So the statement that you need the 60 feet to effectuate the height of the billboard, I think you need to consider whether or not there are other billboards along Route 4 that are static billboards included that are at a lower height. So I guess it's a question, perhaps information for the board, as to whether or not 60 feet is actually necessary, whether or not that's actually being generated by the existing conditions on the site, meaning that I think your team had testified to that it's cantilevering the building because it has to, right? There's nowhere else to go. And that sort of segues into the C variance, a similar question. So you have a site in a zone with maximum permitted impervious coverage, we call it lot coverage is 80%. The site's at about 95%. And although the footprint of the billboard is, we call it relatively small, it's still an increase above that existing 95%. So how does the use itself get subsumed in that case? Or how does the C variance get subsumed in the use in that case?
I'm not sure I understand the question. It's all interrelated to one thing. So the billboard is a structure that on the ground will have a slight uptick in terms of coverage that will take the ground coverage from 95.4 to 95.5. And that can be a factor that the board can consider in its evaluation of the overall use.
But rooftop billboards do exist, right? Like the one in River Edge, like the one in Pagoda. You don't necessarily need to, it's not a function of the use is my point. So the idea that all these variances are necessarily subsumed as a function of the use doesn't seem, I guess, is that accurate?
My point is they don't have to be severable. I don't think there's any benefit to the board saying we're okay with the use, but we're not okay with the 0.1% increase. So naturally, the 0.1 increase could be a factor as part of the billboard itself, therefore it would be subsumed within. I don't know why they would need to be separated.
And just to be clear, I believe there's testimony that increase, although it might be negligible, is not being mitigated at all by any stormwater management.
I don't believe
Based on
it is.
testimony.
That's correct.
Okay. Not to beat a dead horse, all the other C variances, right? Yard setback. So is it your testimony that it's impossible to place a billboard on any site anywhere to meet required yard setbacks? Again, your testimony is that the setbacks are a function of the use. So are there sites anywhere in New Jersey, anywhere on Route 4, where billboards can meet the applicable municipal setback requirements?
I would imagine, yes. I did not do that analysis, but yes.
So the setback issue here is not necessarily a function of the use, it's a function of the property and its developed condition. Is that fair to say?
Yes.
Okay. And you relied upon the lot shape as one of the site suitability criteria, perhaps even a hardship for needing some of the setback relief. But could an alternative perspective be that because of the shape, that it's not suitable because it generates those setbacks? It has the L shape, therefore you require the relief?
The board could certainly consider the shape of the property in that regard. But again, I think you need to look at the physical characteristic of the property and where the sign is going with respect to what's built on it. I think that outweighs the shape of the property in terms of the suitability.
Bear with me, I'm almost there. Now, I think once we're all said and done with everything, I might have a few additional comments, but concludes my line of questioning for Mr. McDonough, so thank you for hanging in there, I appreciate it.
Thank you, Mr. Byrne. Mr. Deputy, do you have any questions or anything?
No, Chairman, not at this time.
He said no, the sound's only coming through here.
Okay.
I was pretty warm there, but again, and I have so much respect for the show. We've been on the same side, we've been recently in court, we've been on opposite sides. And again, I'm not, and I think it goes back to, I believe, what Mr. Sarlo and the setbacks, and quite frankly, not testimony that I heard, other than yourself, that you can't put it at 35 feet, and you can't set it back properly, and you can't do this, and you can't do that. It has to be this. I just don't see the justification. You said on the record, there's no hardship. The building exists today. The parking lot exists today. And you want to put an additional use on this particular piece of property, for whatever reason. I mean, it's a pretty simple reason. It's called money. It's called financial gain. That's the simple thing, and that doesn't impact zoning, and that can't impact anything, one way or another. But based on what I saw in Pagoda, you can put it through a building. There'll be some structural, obviously, changes going on. But I'm not sure how you can say you can't put it at 35 feet. Because there's nothing on the record. There's no document, there's no study, there's no anything. And what's interesting, before you flip the TV screen up there on your laptop, I was gonna ask you if there were signs, but my colleague here got to that. When you were driving around that day, when you never got out of the car, did you see the two signs on the building and what it said?
Yeah, one on each street.
You saw it.
Yeah.
So if the building's at 35 feet, take off a couple feet off the parapet. It's a little bit less, it's at 34, but you saw it. And you see it when you drive on Route 4. You physically see it. And it meets the height. So I'm not sure how you could say on the record that the only place that this use, because you're gonna take the use away, if this board doesn't approve it with those setbacks and that height, you're basically zoning that use into inutility. But yet there's two signs there that everybody on this board, and probably anybody that's driven past on Route 4, either direction, can see them. And they're not at 60 feet, existing. So I'm not sure how you say that on the record, and again, there was one more thing. I said a fall zone. You're not meeting the setbacks. You have a public walkway, you have cars. I always go back to one thing, and it's a terrible tragedy many years ago. Dr. Atkins. He probably had the lowest cholesterol of any human being on the planet Earth, because all he ate was steak. But he walked out of his apartment in Manhattan and was killed. By what? As I froze to death going from my car tonight to this building, he was killed by how? I don't know if you know, Mr. McDonough.
I don't know.
Ice. Took him out, killed him. He might have had the lowest cholesterol on the planet. It wasn't a heart attack. A piece of ice fell off of the building, cracked him in the head, went down, and struck him dead right there. So my next question is, you said it's suitable, it's perfect. What would that do if that happened?
If I fell from the billboard or just the billboard
Well, I'm
itself.
just saying, you're not meeting the setbacks, you're there. So any pedestrian could be walking, there's a sidewalk there, there's a safety issue, I just said it, fall zone, we don't know. Shadow study, we don't have one. Looking in this direction, you don't have it. But you're saying it's perfect, it's suitable here. This is the perfect site, yet you really have, quite frankly, nothing to back it up. And again, I'm not sure, I don't want to take any thunder from a planner. They gave me a planner's license, it's $225 at the time, I got one. But I just don't know how you justify those things. And again, maybe constitutionally, and you have attorneys everywhere up here and in the audience. So maybe we go to court, you can get it. But the question is, how do you get it there? And that's what I think, you can't get it there. Because I think there is no hardship, it's self-created. And you can put it somewhere else where it can meet all of those requirements. Yet you've chose not to. And that's all, that's basically it. But again, it's your testimony, your opinion. I have mine, and I think mine might be just slightly stronger than yours on this case. But thank you, Mr. Chairman, and members of the board and the public, thank you.
Thank you, Mr. Costa. Mr. Burns, you said you might have some final.
We covered most of it. Let me just see if there's anything else. I mean, we went through the statutory criteria, right, for the D1. The issue of special reasons and whether or not the granting of the relief advances purposes of the MLUL, we went through all of that. The issues of site suitability, as well as the negative criteria for D1 use variance. We have the enhanced burden of proof, where the applicant has to demonstrate that the granting of relief is not inconsistent with the intent and purpose of the master plan and zoning ordinance. We went through some of the purposes of River Edge's own ordinance. There was a little discussion of the master plan. I think Mr. McDonough mentioned that the master plan provision that was advanced was a diversity of uses, promoting diversity of uses in the borough. I wonder if that's what the borough had in mind when it put that provision in there. And there are other provisions that talk about, consistency with surrounding development and minimizing impacts in general. We touched on the extent to which there might be negative impacts to surrounding development related to the adjacent office buildings, residential development. So it's up to the board to determine whether or not that's an issue. We covered the D6 height variance. The question of whether or not there's a hardship or any unique topographical conditions impacting the property. The site's flat as far as I could tell, so there's no issues of topography. Then there's a question of whether or not the site can accommodate the problems with the height. In this case, obviously it's 60 feet where 35 feet is permitted. As far as I know, it'd be the tallest structure by some amount in that area of the borough. Negative criteria impacts the public good. Again, we know that aesthetics alone are a governmental interest based on a body of case law in New Jersey. And again, we look at the master plan and zoning ordinance in that context. We covered all the different C variances, which relate to both, not both, but front, side, and rear yard setbacks. We have a minor increase in impervious coverage. We have sign illumination where the borough requires that signs have to be extinguished at 11 p.m. I think we have the number of signs, sign area, sign placement, and there's this question, it's the applicant's testimony that the board can consider that as a package within the D1 use variance. I think that can be separated where you consider a billboard, and you consider context where you can achieve those things. Mr. Costa just talked about that there may be conditions on other sites where you can actually meet that criteria, again, for the board to decide. So, there's the site suitability criteria, and then there's in part the balancing test, right? And in this case, we've identified that there are really no hardships, but so then there's a question of what are the public benefits? How do they outweigh the detriments? The public benefits that were testified to are, essentially a messaging board in this case, versus potential impacts that were discussed. So that's sort of the, an overview of the test that the board has to consider in their evaluation. I think we've covered just about everything.
Of course, in standard in balancing the detriments versus the advantages, is it accurate to say that the benefits need to substantially outweigh the detriments?
I believe it is phrased that way. Yeah.
So it's not a question of if they're even or good, there needs to be a substantial benefit in order to accept the detriments that come.
For the C variances, under the C2 criteria.
Right, and there is no hardship being claimed, so there's no C1, it's all C2.
Based on the testimony. Right, well, again, one of the threshold questions is whether or not the D1 captures that, so, that's something for the board to discuss. I think you can look at it different ways, and, you have to deliberate that issue.
I just want to question that, I mean, so there's really an option or choice to be made whether we handle this as one bulk request for a variance that incorporates the review variances as well as the C2 variance, or we separate them and have two separate motions to discuss. I'm not sure who has to speak.
There you go.
So there are different tests or there are variances that are being required, but I just wanted to remind everybody, we're not going to conclude this application tonight because Mr. Charles is another witness wants to present two other witnesses, including a professional planner. So we're going to talk about all of this more. We're going to move on to the board members, to the questioning. Your name? No.
Thank you. I know Mr. Barron's touched a little bit about lot coverage. So I see in the application that there's currently 95.4% of the lot covered right now, where 80% is permitted. And under, if this sign were to be put up, it would be 95.55%. So my first question is, did this property receive a prior variance to have that much coverage on the lot?
I don't know, but I would assume that this is a lawfully existing property. I did not do research on prior approvals. I don't know.
So did you consider what kind of an impact the increased lot coverage would have on the surrounding properties, considering that there is flooding on that end of town?
Not an engineer, and this is a developed piece of property, and this is a landscape island within the, on the site that actually looks like it does not have any trees, just an open area. And, it's going to be relatively small coverage in the context of the greater plan, a greater site. So, again, it's an infill on a landscape island. It's not the entire landscape island is not going away. It's a very small portion of the island.
Thank you.
Thank you. First of all, thank you everybody for your presentations, for the cross-examinations, for our professionals, terrific work all around. So thank you for explaining and clarifying everything. When were the trees that were there removed from that site, the 3 trees that were there?
Are you talking about where the sign is going? I don't know. I could go back and Google and look. I honestly don't know.
Somewhere between 21 and 25, Google.
Could be.
Because I already looked. Did the property owner get a permit to remove those trees?
I don't know.
Were those trees replaced?
They're not there now, so.
Well, were new trees planted somewhere else on the property to make up for taking those trees away?
I don't know.
In your testimony, you said that this project is particularly suited for the site without having to move or alter anything else. You recall that a few minutes ago when Mr. Charles?
I do, yes.
Okay. Somebody altered that site though. So you don't have to alter or remove the site now, but that site was altered because just a couple of years ago, there were trees there.
Fair.
Would you agree that by looking at our ordinances right now, Riveredge does not want this type of sign and has clearly stated that this type of sign is not something that we want in our town?
I think it's pretty clear, yes.
You talked a little bit about the sign possibly falling. You'd agree that if the sign falls, 3 out of the 4 sides that it could fall on would not be the property owner's applicant, right?
Sure, yes.
And it could fall onto the highway. Let's say a hurricane or a tornado hit, which has happened here in Lake Ledge.
Yes.
Has that been looked at as a possible issue, like, who would respond to that, how would that be responded to? What measures, have, been put into place to prevent the sign from falling onto the highway? Obviously, it caused some damage if it fell onto the property, but onto the highway with moving traffic, drastic, right?
I have not done that analysis.
If we did grant the 60 feet, wouldn't that be a precedent we'd be setting here in town?
Each application would have to be weighed on its own merit based on site-specific conditions.
Couldn't future applicants come to us and say, you did it once already, and this is a similar 60 feet? Now, you know, Kindercomack, there's a lot of businesses on Kindercomack, so why not put a 60-foot sign on Kindercomack where everybody can see it?
The analysis is supposed to be site-specific and fact-based. I think that's what I was asked under cross.
By the way, what was the building adjacent to this application built?
When was the building, you mean the one that's on the site right now? I don't know, I can look it up, but I don't know off the top of my head.
What about the parking lot? What was that, but
I don't know.
was the parking lot last year paid?
I don't know.
Does it have the appropriate number of handicap spots?
I don't know.
Has flooding in the area been considered at all in this application by the applicant and its other questions?
Well, this site plan has been designed by a licensed engineer in the state of New Jersey, so imagine that's part of the engineering analysis.
That doesn't really answer my question. Do you know for a fact? Not imagining, do you know? Was it considered?
I don't know.
Are the current 9 signs along the Route 4 corridor so inadequate so it's a required additional sign?
Are they so inadequate as to, yes,
And how are they inadequate?
we have an applicant here that is ready, willing, and able to, an applicant that is experienced in the field, that is ready, willing, and able to put up a sign, which, the applicant believes will respond to market demand.
And how are they inadequate?
I don't see those other 9 signs empty, which implies to me that there's demand.
How are they inadequate?
They're full, they're at occupancy.
Do you know that there's a waiting line for further apps? Do you have any
I don't.
information that you can provide us with that? Because otherwise, what you're saying is just guesses, right?
There's clearly,
We'd rather you didn't guess.
there is clearly not a vacancy on the existing signs.
Okay, when was the last time there was a date?
I don't know.
We go back to, just very briefly, the aesthetic considerations. We can agree that aesthetic considerations are valid, relevant zoning considerations for us to consider, right?
Part of land use, yes.
And courts have found that the aesthetic impact of billboards is an economic fact which may bear heavily upon the enjoyment and value of properties, near the site, right?
I think we went fast.
Sure. The aesthetic impact of billboards is an economic fact which may bear heavily upon the enjoyment and value of property near the bill, correct?
The aesthetic quality has an
The
economic.
aesthetic impact of billboards, the aesthetic impact,
Yeah,
okay, of billboards is an economic fact. Okay, that bears heavily upon the enjoyment and values of properties near the billboard.
I can't agree with that statement. I don't know who made that statement. I know of no correlation between billboards and property values. I know of no empirical evidence in that regard.
So if I told you I got that language directly from the case, you'd be surprised to hear that, right?
What's the case?
Well, okay. Have we had testimony that there will be negative aesthetic impact in this case?
We had testimony that there would be, no, I have not heard testimony that there would be a negative visual impact.
We heard a statement that there would be a negative impact in this case.
I don't recall that.
Earlier, when the gentleman read the statement from the law firm that's in the building nearby,
Gotcha. Yes, that's an opinion.
that's fine, but that's a negative impact on that individual, right? I
That's,
mean, we're here offering opinions, you're offering opinions, other people will offer their opinions, and we're gonna all talk about it, we're gonna offer opinions, and then we're gonna vote. It's an opinion, right?
that's how the process works, yeah. But I don't
But
know.
there is a negative impact that we've heard about, correct? Somebody has come to us and said, this is going to cause a problem and a negative impact on my view outside my window.
I would state that there has been a statement on the record that adjacent property owner believes there would be a negative impact on their property.
Would you agree that this, billboard could possibly, cause a nuisance
In what respect?
fire hazard?
I have heard no testimony in that regard.
Fall hazard?
I have heard no testimony in that regard.
I see people dropping down on pedestrians.
I have heard no testimony in that regard.
You're saying nothing could happen.
I have heard no testimony that would lead me to have concern in that regard.
You're here testifying?
Yes.
I hear your testimony. Could any of that happen?
Again, we have building codes, we have construction codes, we have all sorts of codes that protect against structures.
Why don't you want to answer the question? Could it happen?
It's a hypothetical. I don't think I have the answer to hypotheticals.
Okay, thank you. Nothing further at this time.
Again, as we said, thank you for the testimony, everyone's attention to that. So I do have a number of questions, issues. I've heard you say that the benefit to the community is a message board, an opportunity for messaging. I don't see that as how does that benefit the flow of River Edge? It may benefit the drivers driving by that learn about a hospital or some other business. But what benefit does that bring to the community of River Edge and the residents here?
Well, first of all, the community is part of the public, and the test is whether it is a public benefit. It doesn't say a Rivervale benefit, it's the benefit to the public at large. Municipal planning does not end at municipal boundaries. That's clear cut in our land use law.
But is there any benefit to River Edge?
Sure there are. Local businesses are, people in River Edge are not foreclosed from using this sign. It will also provide information that may be of interest to people in River Edge.
But we've heard testimony that there's 9 other billboards available for that particular information and many other forms of disseminating that information.
But we have heard no testimony that that's a saturation, that there's too many. There could be an opinion in that regard, but I have heard no testimony, empirical data that indicate or evidence that would indicate there's an oversaturation of billboards in the area.
But just because there's no vacancies doesn't mean that we need this in River Edge.
That's your opinion. I don't have any, I don't share that opinion.
I don't see that there's 9 of these in our area. They're all full, that's great, good for the people that have them. But I don't see that there's a need to add one onto this property. And with that, with all of the challenges on this site, we've talked about coverage, we've talked about setbacks, we've talked about all the challenges of this property. Why was this property chosen as opposed to any other point along Route 4, Route 17, Route 80, or anywhere else in Bergen County where you would have similar traffic patterns and, why are we trying to shoehorn this into this property?
I don't know. They made an application. I was not involved in the site selection process. My job is to evaluate this site and its suitability for this use at this location. Availability of other sites is not a valid consideration in a use variance application.
But as an applicant, they chose this particular property that has setback issues, that has coverage issues, that has a question whether it's even on Route 4. It's a valid question. Why is this why was this site chosen?
But first of all, you use the word issues, it has setback relief and other relief that the applicant is asking the board to move on based on the evidence that it has given them. The board needs to weigh whether that relief is an issue or not, but I'm not going to concede that they are issues related to this site. It is relief that the applicant is seeking. We're trying to give you the reasons why we think the relief is justifiable.
Okay, so with the relief that's needed to have this application passed, why would you choose this property over some other property that doesn't have this, that doesn't have those relief?
Those are really questions for the owner and the company, those are really complicated. He can't answer that, he didn't pick the site, he's the plant.
But we don't have anyone to ask that question.
We can answer one, we can answer Mr. Collins or producer one, we can answer them. The absence of that information is something.
So it just, okay, so I can't get into why this site was chosen, but it does seem that the only real reason that this property is suitable is its location. That we're still trying to shoehorn this onto something that is the only reason it was overdeveloped by the owner or the past owner, whoever. So we have an overdeveloped property. We have, you know, something that is already in need of variances if it was to be constructed now. And it just seems that we're trying to force something onto a property that it doesn't fit. My other questions were more towards that, so I'll get that's it for now.
Thank you, James. Mr. Sullivan.
Thank you for this presentation. Yeah, the other board members.
Can you use the microphone?
Any questions? I'm sorry. Thank you for, everybody's, time and presentation. The other board members have raised some of the questions I've been thinking of, so thank you.
A few questions. First is kind of general comment, hopefully. I noted I took earlier, you know, listing the existing nonconformities and then the requested variances. And now there are some additional that I wasn't aware of, but I'm looking at this list and I've got existing non-conforming houses on an oversized lot, which is interesting. Maximum building coverage, front yard setback, minimum rear yard setback, minimum landscape buffer, and then requested variances, the two use variances, one for billboard use, one for two uses on the site. Height for the billboard, front yard setback, minimum side yard setback, minimum side yard setback, both. Minimum rear yard setback, and now there's also the extension of the required yard and the extension of the building. I guess my question on that is there anything in our code requirements that we've met on that site? Other than the lot size, which is oversized, which should make it easier to conform?
I did not do an analysis of zone conformance. I just looked at the list of relief. Obviously, the existing use is a permitted use on the property. And there may be non-conformances that are there that have coexisted with the zoning for many years.
So, you know.
I mean, I would have to look, there was questions about, does the parking comply, does the handicap comply? I don't know, there's a whole, your ordinance has hundreds and hundreds of line items, and I don't know, I have to go through all of it. I was asked to focus only on the relief.
So, I mean, but again, you know, we have to consider the site and the impact overall, and that includes those sites. Parking is actually a huge issue. It's funny, it was one of the notes I had to ask the governor, but Mr. Greenberg and Mr. Barrington asked me on. You know, do we have the requisite number of parking spots as well as handicap spots? Because if you don't, that further it enhances the difficulty of making sense out of this application and variance. Okay, so, we don't even know where we meet code requirements. And we're asking for more and more exceptions without knowing where it's from. I think it's important for us to know where it's from. I'm confused on your presentation of why the height of the sign has to be raised. Is it because there were obstructions at the lower levels where the signs would exist and has to be raised above them? Is that the issue?
Yes, a driver's height of eye is generally about 3.5 feet off the ground, so you have all sorts of obstacles around you as you go through your complex driving environment. Structures, fixed structures in the landscape and moving structures as well. We commonly see 60 feet as a threshold, or I'll just say not as a threshold. We commonly see 60 feet as an ask for billboards.
Okay. So those obstacles to having vision of the sign at a lower level are part of that saturated landscape you were talking about. Okay, so the problem I have with that is I have a very hard time coming to the conclusion that adding more clutter to a saturated landscape is not a negative impact. If this is so cluttered that you can't put the sign within the height restrictions that we have, that you have to put up at literally double that height. And the reason is because it's a cluttered landscape, because it's a saturated landscape. We're adding to a saturated landscape. I don't understand how that is not a negative impact.
I'm relying back on our traffic expert who talked about the cones of vision and the safety aspect of the sign being where the sign was proposed and height for lines of sight. So again, I'm relying on the predicate of witnesses.
None of that goes to visual aesthetic impact. That goes to, geometry. That's a geometry question. It's not a visual impact. It's not an aesthetic question, and it's not to Mr. Barron's point, with the amount of traffic flow and the amount of clutter, how does that impact those types of issues? Okay, now I'm not asking you to answer that question, but all of those things become.
All I can say is the height moves the sign away from the saturation on the ground level of some of those other objects or obstacles. So it lessens the conflict with those structures.
But it doesn't lessen the negative impact of the crop.
In my view, that's a subjective opinion.
If I've got a saturated landscape and I add to it, I don't think that's an opinion.
But you're not embedding it within the saturation, you're removing it
Right,
from.
so what little bit of open landscape you have comes up.
It's a subjective, in my view, it's a subjective question.
No subjective view of that subject. I guess the other place we're asking too is that you present this property, this site, and as, being a great fit for this use. And there's no alterations here. There's no alterations here, but there is a need to basically take our entire zoning regulations and throw them in the garbage to allow what you want to do on the site, because again, you can't even give me one criteria to that. Okay? So I don't understand how this is uniquely, the site is uniquely set up for this use, when this site doesn't allow you to do it within the confines of any of our zoning. How's that a uniquely, designed site for this use if you can't use it under the kind of reasonable expectation of the level of variances?
Typically, when we write code for billboards, we would have a set of regulations that go with the billboard use to establish reasonable restrictions on use and reasonable controls. You don't have that here because you don't allow billboards. So it's somewhat of a not comparing an apples and oranges comparison, because these are really standards that pertain to a principal building as opposed to the use, which is generally by nature closer to the road than a building may be, generally higher than what may be. Again, in my view, it comes back to the bulk and the related relief, high and the dimensional relief ties to the nature of the use itself. Again, when we do write code that would allow these uses, many of these standards that you see here would be folded in. That's how, in my mind, Mr. Chairman, that's how I reconcile the relief the applicant is seeking. If you're thinking about the use, the bucket of relief that dimensionally the applicant is asking for would go with it. Either way, yes or no, they would all go together.
This is a. Originally, I'm sure. Take a little bit off. Private property, that is. For residential. And it's pretty open. But I want to add a second primary residence. And I want to add a pool, and I want to add a shed, and I want to add a third floor, and I want to do all of these things. And I make the statement that but the property is okay for this use. Why does it follow that I have to allow for an exception to every other standard that exists?
I call it the tipping point. There is a point when the weight of relief that the applicant is seeking certainly tips it into the negative, and that's something the board can certainly consider here. I've tried to give you the reasons for each one of the relief that the applicant is seeking as to why I think it will not be a substantially adverse impact. At the end of the day, it's qualitative analysis, not a quantitative analysis. You don't deny an application solely based on the number of variances. You look at the whole quality, and you could go either way. And that's a negative quality, or that's enhancing the quality for the reasons that I've given. So, I understand, Mr. Chairman, we're adding more to a non-conforming site. I get that. But I don't think we're at that tipping point. That's what I'm saying.
And last question, I asked Mr. Barron earlier about the standard for balancing the detriment versus the benefit. And the standard that the benefit has to substantially outweigh the detriment. Give me your analysis of, in summary, in that, how do you come up with the fact that the detriment here is substantially outweighed by the benefit?
The public benefit here as a tool of communication is substantial. It's important. It's called constitutional free speech. That factors in. I gave you all the beneficiaries of what this message board would serve. That carries weight in my mind. That positive public purpose carries weight here. And again, there is weight associated with the negatives here. That's what we've been talking about all week. So that's at the end of the day where the balancing comes, and the board needs to find that the weight is substantially on the side of the positive as opposed to the negative. That's.
All right, thank you.
Just one, just follow up, I don't know if this is for you or for our professionals. Are there any properties in River Edge that have two uses?
I don't know the answer to that.
Yeah, so I'm not sure if I'm having instructions.
Off the top of my head. Yeah, when we talk about use, talk about definitions, right? So definitionally, what distinguishes one from another, a restaurant versus a retail use could be two different uses, for instance. So in the case of what?
It's part of the variance, so.
Well, to be clear, the applicants requested that variance. I don't believe I've identified, I'm not 100% sure where that variance came from. I think their testimony was that because the ordinance doesn't specifically allow for it, they're requesting it. So being that we're adjourning and coming back, we can look into that because I don't have an exact
Because
answer.
I'm not aware of any,
So
I mean, obviously there's, different retails and there's a restaurant and a Pilates studio, but, are there any you know, they're asking for something that may not even exist in our town.
Yeah, so what I would say is, this is a good time to be reminded that every application has to stand on its own. Even if that was the case, I would tell you go on its way.
I understand that, but if it is a variance, then it's not that we have to approve because someone else has had it.
Right.
But if it, you know, we're still saying this is gonna be, this could potentially be the tallest structure in town, so this could be the first 60-foot structure in town. This could be the first two-use property in Riverview.
Well, it's clear that there's two principal uses. It's clear that they're not related. It's clear that one's allowed, one's not allowed. And the prohibition seems to be constitutionally compliant. Those are facts. So whether or not you need one I'll stop there.
And, yeah, but going back to one other question, Chairman, I think you brought it up. And I asked this, I think it was the first day. You put, whether it gets approved, denied, or you win in court or you don't. It's two separate uses, because I asked one question. It's static billboard. So unless that advertising banner flies by itself and attaches itself, someone physically has to go to the site, park at the site, get out of his car, van, truck, climb up there and do that particular job, right? First question I had, what do they come in? And can they fit underneath the building where they have parking? You asked, what is the parking requirement? And this is going back months, and I think the question was, well, they can park on the street. It's a separate use, so they might need a variance for parking in order to have this particular use and make it happen. Otherwise, they're using off-street parking to establish and maintain this use. But again, I'm trying not to help them, quite frankly, so I don't know if they're gonna come back with additional information. It goes back to the same thing. And what you heard earlier, the D1 gets sucked into, everything else gets approved, if that D1 gets approved, whether it gets approved here or whether it gets approved in another locale, meaning down the street in Hackensack, New Jersey. And that's my opinion, it does not. You need setbacks, you need height, it's a separate use. And this site is particularly suited, and that's why I grilled you more times. And you said on the record, you can't do it here because of that, but there's nothing to back that up. Nothing. So why can't you do it there? Why can't I drill and go through the middle of the building and meet the setbacks and meet all of these things? Why can't you? And I just gave you an example. You can go there tomorrow. It physically exists probably 2 miles from this locale. It's expensive, but it exists. Where they probably would meet the setbacks. They wouldn't meet the height, but they would meet the setbacks. That's it. I'm done. You gotta take the microphone away because some people think it's a deadly weapon in my hand, but thank you.
Given that we are at 10:19, Brad, would you want us to begin with your? Oh, wait, you need to open this to the public. Is there anybody?
There are no members of the public. No members of the public.
And I just run.
Do you want to begin your testimony or do you want to wait?
I think we respect for the board and the time that we're spending rather than chopping up the presentation. Thank you, Chair.
Okay, so we need to see when you can.
Our next meeting date is February 11th. That's Wednesday, February 11th. The one after that is the 25th of February. that gonna take?
I don't know what. We can, that can be, February 11th, we can have the work session, meeting.
Okay.
The question.
So we're good. My planner's not here, but at least the client and architect are.
For the 11th? I don't know if gentlemen.
February 11th, work there?
All right, so the application IAAT Services LLC, 41 Grand Avenue, Block 1405, Lot 4 will be carried without additional notice for the meeting of February 11th, 2026.